How applicable is this suit per what the former Chief Justice seeks from the High Court?
Well, Mr. Speaker, if you remember, when the petition was submitted and the Chief Justice sued at the Supreme Court, at that time I said she had rushed because it was not time for her to have sued. Now, this is the time that her course of action has actually accrued. And so she has the right to sue. She has a very strong standing, and she has a chance to actually overturn the decision of the president. Of course, she would have to meet certain standards before she can overturn the decision of the committee set up by the president. What are these standards? Number one, she needs to actually prove that that committee breached certain laws in making the decision that she had actually misconducted herself. So she has that daunting task to bring evidence to show that the committee actually breached certain laws in coming to that conclusion. Secondly, she also needs to prove that the committee did not afford her a hearing, or the committee did not give her a hearing opportunity for her to be able to defend herself. And a host of other things that she can actually bring to the High Court to show that the committee actually did not do their work well. Now, if she's able to bring all of these things and meet that legal hurdle, then the High Court will be seized with the opportunity to judicially review the work that was done by the committee and make a pronouncement on it. As it stands now, she has filed a writ. The writ is only allegations. And it is only when you have brought your evidence to the court that the court will be able to substantiate those allegations that you are making. So I think what she's doing is right. She's trying her best chances through the legal channel. And I hope that if she has any evidence, the courts will come to her aid.
Now let's start from where she's praying the court through her suit to really halt the vetting process that is scheduled to take place in Parliament soon, as far as the Chief Justice to be is concerned, Justice Baffoe-Bonnie.
Well, like I've said, she always has the right to sue and to demand for justice. Let me try and reduce it into our everyday life. Mm-hmm. Assuming you are litigating with me over a piece of land, and I have already started building on that land. When you go to court, one of the first things you are going to ask the court for is an injunction to prevent me from further building. Because if I'm not injuncted, then by the time the case would have come to an end, you would have lost your rights completely, because I would have finished building on the land and the nature of the land would have changed. Okay. But of course, we are not talking about land here.
Yeah.
We are talking about constitutional matters. Okay. So when we are treading on the constitutional matters like this, the rules are a little bit different. There are several decided decisions of the Supreme Court which have affirmed that when the president or a constitutionally mandated body is performing its duties, you need to demonstrate exceptional circumstances before the court will be willing to injunct that particular body. In fact, some of the decisions have actually said that the president cannot even be injuncted when he's performing his functions as a president of the country. And so there's a balancing scale that the High Court will have to do. I am sure the High Court will consider all the matters in controversy. Of course, on the side of the Supreme Court, the former Chief Justice, her rights, she believes that her rights have been trampled upon, and that if an injunction is not granted against the appointment of Justice Baffoe-Bonnie, then there will be irreparable damage, because by the time the High Court will get a chance to decide and say that she was wrongfully removed, then Justice Baffoe-Bonnie would have already performed the functions of the CG, and therefore the decision of the court, even though will be in her favor, will actually become nugatory, because it will be unenforceable. And so she has a right, and the court has the duty to defend her right. But at the same time, the court also has to perform the Balancing Scale Act to determine whether it can injunct the president together with parliament on performing their constitutionally mandated duties.
Now, without discussing the merits and the demerit of this particular injunction that the former Chief Justice seeks to, put in place, can it be applicable? Can it be applied?
I've already given that answer.
Yes, because you
are trying to tempt me into dangerous waters. The point is that, yes, like I've said, the Chief Justice has a right, and that right needs to be protected by the court. Okay. At the same time, the president, together with the parliament, they also have constitutionally mandated duty to perform, because the country needs a chief justice. And that is why the president has, in accordance with law, nominated someone to be vetted and possibly confirmed as a chief justice. They are performing their constitutionally mandated law. So there's a balancing scale that the High Court is seized with. And that balancing scale is that, do you consider the rights of the Chief Justice, which is being trampled upon, and which rights she may lose it completely, vis-a-vis the duty on Parliament and the President to appoint a Chief Justice to administer justice in the country? And so the High Court will have that heavy burden to balance the scales and make a determination as to which of these ones that the scales will favor. Whether the scales will favor the fact that if the Chief Justice nominee appointment is not halted, the former Chief Justice's rights will be irreparably lost, or whether the whole country, which has decided through the president to appoint a new Chief Justice, whether that the process to appoint a new Chief Justice should be suspended until the court has finished its ruling. That is a very heavy task that the High Court judge has to perform. And I'm not too sure whether me speaking here, I have the competence and ability to determine where that matter should go.
Yes, in as much as you have just drawn this conclusion that you do not have the abilities to really determine where this matter goes, then the question will be, do we need a Chief Justice now? If we do, how is the High Court going to uphold what former Chief Justice Gertrude Torkonoo seeks to get? If we don't, then obviously her application will be granted. Is that not what you are trying to say?
Okay, so let me go back a little bit and talk about the injunction. I think it will throw more light on the question that you have asked me. Because when you go to court to seek an injunction, which is what the CJ is actually trying to do right now, there are certain things that the court will look out for. Number one, what is the real likelihood that your case will succeed? That is one of the factors that the court will look out for. Number two, do you have a right which needs to be protected? I think I've already discussed that one. Number three, if you are not protected and the thing is allowed to take place, is it possible that you can be compensated by way of money? Usually, if the court comes to the conclusion that you can be compensated by way of money, the court will not grant the injunction, because the court will decide that it is not necessary for you to get the injunction, because even if you don't get the injunction and the thing happens, and the court decides that you were right, the court can award damages in your favor. Okay, so that is one of the things that the court will also be looking at. Number four, the court will also look at the fact that that right that you are saying it is being infringed upon, is it something that cannot be, is it something that when it is done, it is irreversible and nothing can be done to compensate you at all? Okay, so the court will have to look at all these four elements before the court will come to the conclusion whether an injunction ought to lie or not. Okay, so now when you look at all of these factors and you look at it vis-a-vis to the situation of the Chief Justice, I'll leave viewers to make their own judgment. Otherwise, I may be taking the seal out of the mouth of the court, because it is only the court that will have the power to make the decision at the end of the day.
Now, we've also been told severally that So, for instance, the legislature, they have the powers on their own to also do their work. How would these lawsuits affect them? Can the High Court really injunct the activities?
Well, in as much as the legislature is independent and performs its own functions, the legislature is also subject to the Constitution of Ghana. You remember, prior to the 2024 election, there was a matter in Parliament, and the then majority leader, Honorable Afenyo Makin, sued the Speaker of Parliament together with Parliament at the Supreme Court, seeking certain reliefs. If you remember very clearly, because of that, the injunctive nature of that relief, Parliament was unable to proceed because Parliament respected the judiciary and wanted to allow the judiciary to be able to make a determination before it decides to work or not. Mm-hmm. There's one school of thought that says that, well, the Supreme Court or the courts of Ghana would not be able to cite a Speaker of Parliament and members of Parliament for contempt because the Constitution is very clear that when they are performing their functions, they should be answerable to nobody but themselves. But there's also another school of thought that believes that to the extent that the Article 2 of the Constitution says that anybody who does not obey the orders of the court can be punished by the court, then it means members of Parliament together with Speaker can also be punished if they decide to disobey. And so, as of now, we haven't had the real opportunity for these matters to be tested, for a court, for example, to decide to punish a Speaker of Parliament or Parliament for disobeying the orders of the court. And we have also not had the position for Parliament to also decide to react to. Remember, it is Parliament that approves their budget and all of those things. And so those are areas that are quite interesting. I would say there are areas of our law that are still developing. And I believe that there will be opportunity one day for some of all those three areas to be tested for us to know exactly what the courts and Parliament, their limits are. But as we speak now, I can tell you that if the High Court grants the injunction application of the Supreme Court, former Supreme Court, former Chief Justice, I believe that Parliament of Ghana will respect that injunction and refrain from proceeding with the vetting. On the other side, I also think that until Parliament has been injuncted by the court, Parliament is free to perform its functions.
You did mention that this is the right time that you were expecting that she'll pick this issue up. And one, if she's able to establish that she was not given a fair hearing. How is she going to establish that when indeed, prior to the committee's final verdict, she came up with some few things saying that the environment she was invited to come and really speak to her own issue were more or less very intimidating environment. So clearly, I mean, she herself has established that she was given a hearing, but she felt the environment was quite intimidating.
Well, that is correct. She herself has come out to say that she attended a hearing. Regularly, we would all agree that that is a hearing. But you remember that, don't forget that in court proceedings, it is not a one-day affair. So let me bring it back to normal court proceedings. Yeah. If I should sue you in court, and we go to court, let's say on Monday, and the judge decides that the suit has been adjourned to, let's say, next week, Wednesday. Mm-hmm. And at the time the suit was being adjourned, you were not in court, okay? But you are aware that you were supposed to have come on Monday. Now, because you were not in court, the judge will now order me to serve you with a hearing notice to tell you that we are coming back to court on Wednesday. If I fail to serve that hearing notice, and we come on Wednesday, and the court continue to proceed with the trial without you, you can come back and claim that you were not given fair hearing. Because on a particular date when we went to court and the case was adjourned, you were not served with the letter, if I may use that word. You were not served with the letter that would invite you for the next court hearing. Therefore, you were not aware. Okay? So even though we are all aware that the CJ attended the proceedings. Don't forget, her lawyer, Ni Ayuko Otu, has told the whole world that when on the last date that they attended the hearing, they were supposed to file written addresses, and the committee gave them 1 week to file that written addresses. And before they could present their written addresses, the committee had already presented its findings to the president. So they could explore that option to see whether the High Court will give them the nod that meant they were not given fair hearing or not. I'm not saying that is what the High Court will say, but I'm just saying it is one of the areas that they can explore. There could be other areas. You know, you and I have not seen the full report and we have not read it. And so we don't know the nitty-gritties in it. But I believe that her lawyers who were there with her, they have seen the full picture of what happened. And whatever loophole that is in the committee report, they will definitely seek to exploit that loophole to the advantage of the former Chief Justice.
Counsel, let me ask you. So, for instance, with what the Honorable or Lawyer Ayuko said, that they were given 1 week to come up with written addresses, and before that 1 week would be, could the committee, in proper terms, have submitted their report without taking the written address from them? And was it proper? Let me just get your view. This is not to say that what you say is exactly that, but I'm trying to get your view on that.
Okay, so ordinarily, in everyday court trials, after we have done the full trial and the judge has taken evidence, normally the judge will give lawyers opportunity for us to address him or her to write our written addresses. Now, there are instances that the judge will say, okay, I'm going to give my judgment on 24th December. So lawyers, please make sure you file all your written addresses by, let's say, 10th December. Because if by 24th you have not filed, I'll definitely give my ruling.
Yeah.
Now, what this means is that whether you file or not, the judge is going to come up with a ruling. And that is pretty much the position of the law. The judge will normally give you the opportunity to file your written addresses. But that written addresses are not binding on the judge. They are just to draw the judge's attention to areas of your case that you think are very important. And so if they give you time within which to file your written addresses and you don't file, they still have the power to go ahead and make a determination whether you file or not. So if I'm to apply that to the work of the committee, then I want to believe that, yes, even though they gave the lawyers opportunity to file their written addresses, if the committee felt that they have gotten the necessary information they needed, and that information has given them the ability to make a determination, they can go ahead and make a determination without actually reading the written addresses of the lawyers involved.
So clearly what it means is that the written addresses couldn't really make any impact on the final verdict.
It depends on the ground rules that the committee used. One thing about this presidential committee that investigated the Chief Justice is that there are no known rules of procedure for that committee. We as practitioners, we know that when you go to the district court operates with what we call CI 59, the district court rules. So when we go there, that is the rules we use to work. When we go to High Court, we all know that the High Court uses the CI 47, and that is the High Court Civil Procedure Rules. That is what we as lawyers, we all use, okay? When you go to the Court of Appeal, there's CI 16 that the Court of Appeal use. Now the question is, which rules does this committee use? There are no rules for the committee. Some of us have said that the rules of court committee must be given the opportunity to write rules for this Article 146 procedures, so that in future, when anybody is being dragged before any committee, the person will be aware that at this committee, these are the rules that work. And so when I go there, this is how I'm supposed to conduct myself. But as we speak now, there are no rules. Article 146 itself is silent on whether or not we can make rules for that particular committee. So I believe it's quite a troublesome area. But be that as it may, normally, even if the committee doesn't have rules, the committee is generally expected to abide by rules of natural justice, fair hearing, notices, and all of those things to be able to do its work fairly and impartially.
And in that direction, who should set that rule?
In this particular instance, Article 146 is silent on whose responsibility it is to set those rules. I want to believe that the Rules of Court Committee can be given that power to set up those rules because they have experience in setting up rules for all the judicial bodies that we have in this country. But to be very honest with you, Article 146 was very silent on whether or not such rules can be made for that committee.
Even though we haven't, seen any communique from the court to telling us as to when this particular injunction, the dates that will be set aside to really either grant it or refuse it. What is the position of the law when it comes to some of these things? How soon are we expecting the High Court to really set us a date for such ruling?
Okay, so normally, when you go to the High Court to file a motion, you take a date from the registrar. So I believe if we have seen the court documents, we would have known the date that is on it. Because normally for High Court, the day you are going to file, you go with all the possible dates that are good in your diary. And the registrar will choose one of them and write it on the document that you brought so that it will be fixed on that day for you. I believe it's because the document has not gotten into the media. That is why we don't know the exact date. And it's normally in the Supreme Court and Court of Appeal that when you are going to file something, you cannot go with your own date. You file and go home, and then when the judges are ready, they will set the date and invite you to come. Whether you are available or not, you have to be there on that day. So since this is a High Court matter, I believe the date has already been set, except that the court documents have not gotten to the media. That is why we don't know the date.
All right, Counsel, I'm just taking a break. We'll be September 1st, 2025. Still joining us is a private legal practitioner, Richard Niama. Now, Counsel, what rights are we as a nation trampling upon as far as the former Chief Justice case is concerned? Did she deserve any salary and entitlement?
Okay, so to the extent that the Chief Justice does not agree with the decision of the committee, it is inevitable that she will be holding such a position in the court because she's definitely disagreeing with her dismissal. And once she's disagreeing with her dismissal, then it means she's asking that her salaries and all other emoluments must be paid to her. Mr. Speaker, to be very honest with you, with all these things that have gone on, I believe the most painful aspect is the fact that with her removal, she's going to lose even her pension benefits because with judges, they do not contribute to Senate.
Yeah.
They don't contribute to any pension scheme. They retire on their salary. And they take the salary that they were taking as judges until the Lord calls them. And so if you imagine that the former Chief Justice, who has worked all her life, I knew her when I was in law school. At that time, she was a very brilliant Court of Appeal judge that we all admired. Once in a while, she would come and lecture us a few times and go back. So having sacrificed all her life to work her career to get to this level, only to be dismissed in such a way that not only is she losing her salaries now, but she's also going to lose her pensions, I think it must be a very tough one on her. And so definitely she's going to fight for some of these things. I feel that this is not to fault the Chief Justice. She has every right to conduct herself in the way that she likes. But I feel, that's my opinion, that looking at the constitutional arrangements about the removal of a Chief Justice, the moment the petition was submitted, and the president actually took steps to find out whether there's a prima facie case, I thought at that point in time, it gave a very strong signal that the government would go ahead to set up the committee. And if you look at the structure of the committee, I don't expect that when such a committee has been set up by the president, any Chief Justice will go through the process and come out innocent. Because we have two justices of the Supreme Court who are members of the committee. And there are 3 people who are not Supreme Court judges, but who are appointed by the president to sit on the committee. And so, assuming the 2 Supreme Court justices decide to even save their colleague, there are 3 members there who have majority, who can overturn that situation. So for me, again, it is my personal view, and I'm not faulting the CJ, but I felt that the moment she saw the signals coming, she should have probably negotiated her early retirement so that all these things would go away from her neck. She could have gone home with her retirement and enjoyed her salary until the Lord eventually calls her. And she's still a young person. I believe she could have even come back to the bar to practice if she wanted, because every judge is still a lawyer. If you are not a lawyer, you cannot become a judge. And so once you have taken an early retirement, she could have decided to even write books, or even gone back to teach, or even practice the law, which nobody will prevent her from doing. Of course, people will say, "Oh, but she was a CJ, bowing. Everybody was bowing to her." But I mean, it is a profession that we have all given ourselves to do. So I thought she could have taken that route, but unfortunately, it didn't end that way. So now she's saying that all those entitlements, to the extent that she does not agree with the work of the committee, she also does not agree that the president should stop those entitlements. And I believe that is why she has gone to the High Court. So let's see what the High Court will say about it.
It's obvious from what we are being told that before the final decision that was taken by the president to remove her from office, she was still not being given her entitlement. What have you to say to that?
Well, that would be a bit strange to me if they actually stopped her entitlement when she was suspended, because as far as I'm concerned, the suspension is just like an interdiction.
Yeah.
And in Ghana here, whenever you are interdicted, the police service, the military, doctors, all of them, when you are interdicted, you get a percentage of your salary until the investigation is over. If the investigation is over and they decide that you are innocent, you come back and get your full salary. If they decide that you are guilty, then they terminate the salary completely. So if upon her suspension, her salaries were completely stopped, I think that was quite far-reaching. But of course, it may well be that is what the judicial service, their conditions of service says. I have not read it thoroughly, so I'm not too sure if that is what it says. But it may well be that is what their conditions of service say. Otherwise, it was wrong.
All right. Now, counsel, let me ask, withholding her salary and her benefits, are we not putting justices and chief justices in a certain fix that if care is not taken due to some of these things that we have triggered, in fact, triggering the Article 147, 146, in the nearest future, at least every other chief justice that comes will not want to position him or herself in a certain way such that if this thing is triggered and he or she is finally removed, he wouldn't go home and go and struggle, which, in the end of the day, may promote corruption one way or the other.
Well, those are governance issues, and they are legitimate questions that you are asking. Of course, there's a reason why the framers of our Constitution set the salaries of justices the way they did, because they didn't want money to be a problem to them. Because if you are a judge and money is your problem, then you have a big problem, because people will be able to entice you with things here and there, and you may compromise along the line. And so Yes, these things are very worrying. And I personally feel that with what has happened, I think it is time for us to relook at Article 146 and either amend it or fortify it in such a way that anytime any such petition is submitted, it will be devoid of political polarization. Because the whole problem, in my view, is the fact that the president is involved. And I feel that if a body is set up independent of the president to be in charge of looking at Article 146 complaint and making its own independent decisions, we will not be where we are today. When I saw some of the headlines on the international media, I was very, very sad because it painted Ghana as a country where the president can just get up and remove the Chief Justice anytime he or she wants. But of course, we all know that is not the actual situation on the ground. So I agree with you, and I believe that Article 146 certainly needs to be relooked at so that we can enhance the independence of the judiciary and ensure that when they are delivering justice, they will not be looking over their shoulders.
Now, with what has happened, does it give Chief Justice's security of tenure office?
Oh, certainly. There is security of tenure of office for the Chief Justice because once you are appointed, unlike a minister or a CEO or a DCE, the president cannot just get up and say, I'm sacking you tomorrow. Look at all this process that the president has gone through, even if it was the wish of the president to sack her. Look at all this process that the president has gone through. I don't think it is an easy process. And so you can agree that there's a security of tenure of office. But then there's a loophole. And the loophole is such that if the president of the day doesn't like you to be in the office and somebody submits any petition, the president can trigger the processes to ensure that you are removed. And that is what we need to work on the constitution and make sure that that loophole has been closed.
Is that not why some school of thoughts believes that it's more or less been a very bad precedent, looking at the fact that ever since we came to the Fourth Republic, almost all our chief justices have enjoyed their tenure till their retirement stages?
Yes, of course. Political activists and even some international organizations have seen it as an interference in the judiciary. Okay, and they are not wrong to look at it from that perspective because whether you like it or not, the president has been involved in the process. And once the president is involved, certainly it will raise political questions and people will answer it the way and manner in which they want it. So if we really want to make sure that it doesn't become a political matter, then the right thing is to amend the constitution and ensure that in future, if there's any petition like this, the president doesn't get involved at all.
Should we tamper with Article 146?
Maybe temper might be a strong word, but I think Article 146 needs to be reviewed. And I believe that now that the Constitutional Review Commission is in session and they are working, they should look at it and come up with better solutions. If for nothing at all, even if nothing will be done about Article 146, I believe that we should find a way to set up rules and procedures for every Article 146 inquiry in the future, because it is so great. It's as if once they make you the chairman of the committee, you can come up with your own rules and deal with the matter the way you like it. And I think it doesn't promote consistency, it doesn't promote fairness, it doesn't assure that the process is going to be fair to everybody, irrespective of your background.
Councillor, how about those who believe that the CJ seat is not a fixed traditional stool occupants can really claim as a right, looking at the fact that the former Chief Justice is seeking right here, right there, right here. And then it's as if once you assume that office, upon assumption, you have a right to everything and nothing could be touched as far as the occupancy is concerned.
Well, there are processes through which Chief Justice appointments go through, as has been done for Justice Baffoe-Bonnie. I mean, you are nominated, you go through Parliament, and then you are confirmed, and you become the Chief Justice. I sitting here, nobody can nominate me to become a Chief Justice because I do not qualify. Before you can become a Chief Justice, you must have qualified to be on the Supreme Court bench. And the qualification is that the person must have been a lawyer for at least 15 years of good moral character and proven integrity. Okay, so to the extent that the Madam Torkonoo had those qualifications at the time that she was appointed, she accrued some rights, because once you are appointed into the position, some rights and benefits are accrued to you. And those are the rights and benefits that she's fighting for, because she believes that the process that removed her was unlawful. Of course, you and I will agree that on the face of it, there was nothing unlawful about the process, because as we can all see, the president went through all the procedure prescribed by Article 146. And the result was that the former CJ should be removed, which has been done. If she doesn't disagree and she's fighting for her rights, she has a right to fight for her rights. And let's see what the court will say about it. Of course, we know it is not like chieftaincy, but once she has been appointed, she has some rights.
Let me ask the very final question. The petition around her was because she was the Chief Justice, right?
Mm-hmm.
So if she's been removed as being the Chief Justice, couldn't she have gone back to the bench?
That is my personal view. I have said it many times that I believe that if the person has been removed as Chief Justice is administrative role. And if you look at the allegations against her, those were allegations that can only be made against a Chief Justice, like the traveling and all of those things. It cannot be made against an ordinary Supreme Court judge who doesn't have those privileges. So I felt that, or I think that if she has been removed as CJ, she could retain her position as a justice of the Supreme Court. But I've been also, my attention has been drawn to the Ejechum case.
Yeah.
In the Ejechum case, the Supreme Court had the opportunity to make a pronouncement and say that because the qualifications for Chief Justice are the same as the qualifications for a Supreme Court judge, if you become a CJ and you are removed, it means you have also been removed as a Supreme Court judge. And I think that is exactly what the president did.
Well, most graceful, lawyer Richard Nneama, for your time on Newsnight, Friday night like this, speaking with us on Bullet TV.
Thank you very much, Mr. Speaker.
So that was a private legal practitioner, lawyer Richard Nneama, speaking with us this evening. We dealt solely with issues around the former CJ.